numbers, but high in quality. Let me welcome the married band to the discussion of GTMO. What next? I'm David Rivkin. I have the privilege of being a moderator of a very able panel. I'm going to introduce them briefly. I'll introduce myself in one sentence. I'm a partner and head of appellate practice at BakerHostetler, and I'm going to introduce very briefly very distinguished speakers in the order in which they're going to appear, and then we're going to, instead of delivering prepared remarks, we're going to pose some questions. I'm actually going to pose the questions to the panel and take some of your questions if you're interested. So first we're going to have good friend Charlie Dunlap, who is now at Duke and had a distinguished career as a military JAG, rising to being the deputy JAG in the Air Force. Written a great deal about all sorts of issues relating to the laws of war and related issues. We're going to have, and I apologize if I mispronounce the name, Raha, who is the Director of National Security at Human Rights First, which is a very venerable organization that has participated in pretty much all of the discussions of post-9/11 counterterrorism policy and participated in a variety of litigation efforts. So I may disagree with my colleague here, but
maybe less than you think.
Maybe less than I think. That'll be a great fusion. Next, we're going to have Lekas, who is now in private practice, but spent a number of years at the Defense Department as one of the top lawyers, an officer of General Counsel, and had a very broad portfolio, which included those types of issues. But not the only ones, and last but not least is Paul Lewis, who was DoD Special Envoy for closing of Guantanamo Detention Center, which, as most of you undoubtedly know, was a policy priority of Obama administration. Never came to pass, but I'm not going to hold us responsible for it since there was some formidable opposition. Why don't I proceed as follows? True to a panel's title, let me first, so I'm going to pose a range of questions and we'll proceed in the same order as speakers are listed in the program. So the first question is, A, what is the Trump administration likely to do with Guantanamo? That should be an easy question. I can answer it myself. But more interesting question is what should it do? And to infuse a little bit of flavor into a second question, I solicited questions from all of the panelists, and one of them I think fleshed out very nicely, sort of a series of important sub-questions that should guide the decision whether or not Guantanamo should be closed as distinct from will be closed, because again, odds of 100% it would not be closed. Didn't even get closed under Obama administration, that was all for it. So chances of being closed under the Trump administration are pretty infinitesimally small. But just to flesh out a couple of things, then I'll turn it over to the speakers. So what is there really a serious evidence that closing Guantanamo would have any beneficial impacts as far as our relations with our allies are concerned, taking into account, of course, that pretty much all our allies have criticized Guantanamo various levels of stridency, how they're measure the improvement, if any. What should we make out of the fact that Americans do not want to have folks from Guantanamo right now come to the United States and reside either in the military detention facilities, of which there are several, or a supermax civilian prison? It gets into questions of security, escapes, etc., etc. And what about the fact, which I joked with my colleagues before we began, that from a creature comfort perspective, I'm sure that detainees would agree with me. Back in my days in justice, I visited several Federal Bureau of Prison facilities, and I visited Guantanamo 3 times. Ladies and gentlemen, I'd rather be detained in Guantanamo any day of the week than being detained in a supermax. There's just no question about it. So if you're interested in what they want, what their lawyers want, they want to be let go. Anyway, to the extent we close Guantanamo as a detention facility, we're obviously not going to give Guantanamo as a military base. Would that wipe out any positive PR benefits? So you know, let's talk about this and see what my colleagues think. So again, the first question is, what should the Trump administration do? As I said, I tip my hat, that's easy, but so what will it do, but what should it do?
Yeah, I mean, interestingly, I think it might be less easy than we presume. So the Trump administration, you know, President Trump, when he was campaigning, said that he wanted to, you know, fill Guantanamo up with some quote-unquote bad dudes, which was shorthand for adding the population at Guantanamo, presumably with terrorism suspects or individuals captured in theater. However, we have seen now in the first 6 months that no one has been added to Guantanamo. And in fact, in one of the few high-profile cases with an al-Qaeda suspect picked up originally, I believe, in the UK, transferred to Spain, and most recently transferred to an Article 3 court in the United States under the Trump administration. The press had treated that transfer as a concession by the Trump administration, that it didn't, it no longer was preferring Guantanamo as military detention or trial option. I think it's more complicated than that, and we can get into the reasons why. But I also think the fact that we have not seen a significant number of transfers to Guantanamo under the Trump administration, and have seen some evidence, at least, of an interest in using Article 3 federal courts, shows that it's a much more difficult kind of policy problem than sometimes is characterized in the press. In terms of what should the Trump administration do with Guantanamo, I don't think it'll be a surprise to anyone. You know, I'm sort of the token human rights guy on the panel. But I'm in favor of closing Guantanamo. Yeah, fair enough. But I think there are important legal and policy reasons and moral reasons for closing Guantanamo. We can get into it in the broader discussion, but I wanted to just start off with a bit of an informal poll. How many people remember when President Obama said that he wanted to close Guantanamo because it was a distraction for our allies and a propaganda tool for enemies? It was actually a trick question, because that quote is not from President Obama. Yeah. It's from President George W. Bush. Right. And in fact, it was the considered view of the Bush administration that they wanted to close Guantanamo. It was something that was suggested by the military and legal advisors for a variety of reasons having to do with not only diplomatic efforts, but actually concrete counterterrorism and national security reasons. So we can have a conversation about that as we kind of go on, but that's sort of my little trick question pitch in terms of framing this in this conversation, because I do think sometimes it's put in unnecessarily political or partisan terms when in fact it's a much more complex.
Before we go on to exercise moderator's prerogative, just because a fallacy is bipartisan does not make it any less of a fallacy. I'm frankly not particularly concerned that we in the last 2 or 3 years are saying that. The real reason I hope we can kick this around is, why does it make sense? And again, to put my biases on the table, to me, people who close Guantanamo and many other things that would remain something they want, but essentially vitiate the totality of laws and war paradigm, which includes military detention, trial of military commissions, a robust use of force suitable for warfare and not police operations, et cetera, and we cannot do that and survive as a democracy that's threatened by very insidious and robust enemies. So unless we agree that in those terms, Guantanamo makes sense, I'm not going to go with it. Anyway.
Well, I'm going to kind of focus just on Guantanamo, because I think is it a distraction for our allies now? I don't think it's on the radar screen. And frankly, to the extent that people around the world think of Guantanamo, they think if we don't completely close the base, they think the base is only the detention facility. I think there's zero possibility that we'll close the base for many reasons totally unrelated to detention. And I do think that we do need to have a detention facility. And one of the things that the American people have consistently said, polls show, that they don't want Guantanamo closed and they don't want the detainees transferred to the United States. And I tried to find a single jurisdiction that was willing to accept a facility, even with a pretty substantial amount of federal support, and there isn't. Not even in the county in Colorado where the Supermax is, and the governor of Colorado has said that if they try to move the detainees to the Supermax, he will do everything he can to oppose it because the local people don't want it. And I do think there's an open question as to security because, you know, in this state, at the maximum security prison, not too long ago, we had 2 murderers escape and were on the land for, you know, I think a couple of weeks. But I think more than that, I think one of the reasons why there's no jurisdiction that wants the detention facility is because they know it will become a lightning rod for continual demonstrations. Everything that, you know, every policy issue that people don't like about the United States, even beyond detention, this will be the place that they will decide to have their protests and so forth. So I think that there's some good logical reasons to keep the facility open. We have to have a facility. It has to be somewhere. I think we've already paid the reputational price. I think closing it now won't, I don't think there's any data to show that there's any country that will suddenly love the United States if we close the detention facility at Guantanamo, particularly if we move the detainees to the United States. And that will complicate the litigation, obviously, for the military commissions, because we do have Dominion that talks about habeas rights, but they're really, to my knowledge, and Paul, you've forgotten more about, the Pauls have forgotten more about this subject than I ever knew, but I don't think that there's been any definitive ruling of the application of other parts of the Constitution to military detainees, law of war detainees. So that will generate a whole new level of litigation that we may not need to have.
Right, can I just add to this? I happen to think I'm not very keen on the Supreme Court decisions, you know, particularly following Hamdi, but it is what it is. But Charlie is right. You can at least make a conceptual argument that habeas is a different animal, constitutionally speaking, and just because sort of habeas not being extra-constitutional, but really is a part of integral authority of all courts, including Article 3, that they can take a more ecumenical view of availability of habeas. Constitutional habeas, not statutory habeas, does not mean that the rest of the Bill of Rights applies to the situation. But if you bring folks here, the case law is pretty clear that if you're in American soil, whoever you are, you can be an illegal alien, you can be an American citizen, you can be a permanent resident, you can be a combatant. The Bill of Rights would apply, and I shudder to think about litigation about prison conditions, despite having said that Guantanamo is actually pretty comfy. I'd hate to have challenges to prison conditions and availability of literature and all sorts of other issues that bedevil confinement in federal and state penitentiaries. So we'll be buying an enormously difficult set of issues with no particular benefits to offset that. Paul and Paul?
Wait, I'm sorry. So, Charlie, your premise was we have to have a detention facility. We got 40 people. We got a country of 350 million. Why do we have to? I mean, that's you said it a couple times, that's the underlying premise. We have to have a detention facility. I'm lost.
Can I try?
Why do we have to have, for these 40 people, why do we have to have a
where would you put the 40 people? Would you release the 40 people? Khalid Sheikh Mohammed and so forth?
I don't know how many of those 40, because I don't know enough of the facts of the individuals.
41.
41? But we had German POWs in the United States. We didn't establish separate farms in Brazil to ship the German POWs in World War II.
Well, I would suggest that the legal and social and political environment today is different than it was during World War II. And we had about 400,000 Nazi troops here, 400,000 or 500,000 Nazi troops. Would you want 400,000 or 500,000 ISIS fighters in this country. I don't think you would. I think the nature of the threat in our environment is different.
Are you really suggesting that ISIS is less of an existential threat to our country than the Nazis were?
Or more, no.
No, I
Because they're clearly
think
less of an
I
existential
think the norms applicable to POWs were different then than they are with respect to the motivations of terrorist suspects. So I think terrorist suspects represent a different kind of threat.
Charlie, I mean, those POWs would have
Well,
included
where-
SS stormtroopers. I mean, they're certainly an SS stormtrooper.
No, we're talking about the norms of when they're in confinement. And they did kill each other. There's a graveyard at Leavenworth with 30 or 40 Germans who were executed by court-martial in this country for what they did to other POWs. But where would you want to have?
Well,
what would you do with the 40 detainees?
David's trying to.
No,
I'm sorry, I don't mean
let me
that.
step back, because I
Yeah,
think.
but are you saying we shouldn't have a
Well, that's the question.
That was the question.
Okay, because
Yes,
let's forget
yes.
about for a second where. The antecedent question, most fundamental question is, should we have a facility to detain, and by the way, Charlie, I respect you greatly, but I don't like to use terrorists, because terrorists should be detained in the civilian justice system. We're talking about unlawful enemy combatants, which is a different animal.
You're talking about that.
We don't overlap. Okay, I know you guys don't accept the category exists anywhere in international law, which underscores my point that there are a lot of people trying to destroy the entire laws of war paradigm. But my point is we are at war. It's not a war we've chosen. It's not just those 40 people. Well, 40 people, it's a palpable enough fact. We're going to wage war against ISIS. We're going to wage war against our organizations. From time to time, we're going to capture their members. They're not just criminals. They're not just terrorists. They're enemy combatants. If we're going to take the laws of war paradigm seriously, it animates and informs many things we do, then we need to detain them as enemy combatants. If you accept that, we can have a bit of a debate, should it be 11 or should it be in Guantanamo, but let's at least agree that there should be a detention for captured enemy combatants. And if we have war with North Korea, God forbid, and we capture North Korean soldiers, who would be presumably POWs, we should also be able to detain. Do you disagree?
No, I don't actually. I mean, the problem is, of course, what we've created is a sort of a hybrid, where, because I agree with you, and I think, you know, certainly the military officers that were involved at the beginning of this torturous process, I think agreed that we should treat them in accordance with well-accepted norms for treating enemy combatants. The problem is what we've created in Guantanamo is a detention center that doesn't, because of some of the treatment we decided to employ, we've sort of created a hybrid. I agree with you, we should have I'm okay with a POW camp where we have people who are treated in accordance with the laws of war. But that isn't what we
except
created.
that you have to qualify as a POW. The Geneva Convention, you know, we're talking about Article 3 security detention, not the Geneva Conventions don't, you know, have certain requirements for prisoners of war. And that has to be, you know, once we start backing off and making up things that the Geneva Conventions require or don't require, I think that can be very problematic. So we do have a security detention, and I think we have to have a security detention for the, you know, there are going to be some people who present a security threat that fall into our hands that we have to treat in accordance with, you know, it's an Article 3, Article 75 analysis as opposed to the traditional POW analysis. But I think we have to have a place for those people.
Okay. And sorry, I'm going to turn it about this one point. It's not just American interest. It is if you care about humanitarian law, and we live in a world where there are rampant violations, grave breaches, to use a technical term, Geneva Conventions. Russians are lurching from one atrocity in Ukraine to another. It is essential to reaffirm the importance of complying with the 4 criteria of lawful combatants. And if you kind of normalize deviancy down, if you say, well, it doesn't matter, you carry arms, you kill people, they're going to be POW, that would be a horrendous blow to humanitarian law, at least in my opinion.
Yeah.
Paul? Go ahead. Duly, Paul.
No, I mean, I think, you know, when we talk about what is going to happen, what should happen under this administration. We do need to look at the two populations separately. There's the group of 41 who remain down in Guantanamo, and I think for a number of qualitative reasons, we need to consider those and what the appropriate disposition is with those individuals differently than we do for anybody who is future captured. And we haven't added anybody to the population at Guantanamo in many years. And there's no, at least from public sources, there's no prospect that the Trump administration plans to do that. But what are we going to do with individuals who may be captured on the battlefield? What are we going to do with any ISIS combatants who are captured? Are there plans, should there be plans to send them to Guantanamo? I take David's point about reinforcing the law of armed conflict paradigm. I think it is important to affirm that we are able to detain individuals in compliance with the law of armed conflict, even individuals who are associated with non-state actors as opposed to states. I think that's important, but we don't have very much practice recently. I believe there's only a couple of cases where we've actually detained individuals, but not at Guantanamo and other places. And those detentions have occurred only for limited periods of time. But what should happen? I mean, should the Trump administration bring more individuals to Guantanamo? Should there be an international detention facility that is created to hold individuals that are captured by the United States or its allies? Or should we continue the same practice that we've embarked on over a number of years, which involves not detaining individuals or turning them over immediately to third-party states? Paul.
Yeah, so Paul and I are used to this. We've been getting each other's emails for years. We're kind of a package deal. Both Paul L's working at the Department of Defense. Couple fundamental points. I mean, we all want to protect the country. If you use force, you're going to have to detain people. We are using force. We're going to have to detain people in the future. The questions are where. If it's not GTMO, is it going to be a domestic location? Is it going to be in the third country? Is it going to be on a ship? I mean, we're going to detain. We have to figure out a way for future captures. Will it close during this administration? I'll use a word I use with my kids a lot. That will be challenging. Should they? I would suggest that this administration look at the two previous administrations. As Raha said, at the end of the Bush administration, they came to the principled conclusion that GTMO was not sustainable. Not that it was wrong. We need to detain people, but the GTMO location, and David and I have disagreed on this, I think the location matters. It's a symbol. Wars are political. I do believe there is data that our allies, it's more than a distraction to our allies. My colleague at the Department of State, Cliff Sloan, is famous for saying that he's been approached by allies of ours, significant allies in counterterrorism, that have said the single most important thing we could do to help the war on terror is to close GTMO. And I know the country he's talking about, and it's a very significant country. General Petraeus said that the most important thing we could do to win the war on terror would be to close GTMO. Not that GTMO itself is a bad facility. It's the symbol. It's conflated with Abu Ghraib. It's conflated with torture that occurred by the CIA, not at GTMO. But to a 17-year-old in Pakistan, GTMO is the symbol for what we've done wrong. So both President Bush and President Obama made the same principled conclusion that it hurts our national security to keep GTMO open. It hurts us more than it helps us. Why? It's wildly expensive. Two, it is a recruiting tool. It is a propaganda tool. If we close it, is that going to take that issue off the table? No, but it's going to take it partially off the table. And we're talking to the reasonable people around the world. It is a distraction with our allies. In addition to what Cliff Sloan and General Petraeus said, I've met with MPs from the United Kingdom who said they will not send people for intelligence purposes. They will not share intelligence with us if they're going to go to GTMO, because they have concerns over indefinite detention, even with the safeguards we have now. They have said, the same MPs said they would vote against their appropriations bills. But what I look to is the lawyers in the Bush administration, John Bellinger, Matt Waxman, both at DOD and State Department, favored detention but said GTMO is not sustainable, that it had hurt us with our allies. Would it be difficult to move to the United States? Yes, there are going to be legal challenges, but it's subject to the judicial system already. Will there be security challenges? Yes, but I think we can address them with a number of 41 and maybe some additional captures by the Bush administration. I think Charlie's right. It'll be a flashpoint, but I think we can do this. We have good intel. We would know what the issues are going to be. Politically, the Obama administration worked on getting the number of detainees down, so it's down to 41. They never really made a hard press with Congress. I think with presidential leadership, which might be an issue in this administration, but with leadership, you could convince a state to do it. There is interest in Thompson, there is interest in Thompson, Illinois, there's interest in Michigan, there is interest by some folks in Colorado. I think you could make it happen with a small number. So that's what I think we should do. It's the cost, the propaganda, recruiting, the cost of our allies, and then President Obama made a fourth argument, the moral argument, that we can do better. We are the superpower, we are still the leader, the world expects us to detain in a place that's transparent, where there is no allegations of torture. I don't agree with him completely that this is a moral issue, but the world views it as a moral issue, and I think we can do better. So I look forward to continuing the discussion.
I've got to counter that.
Sure.
A couple of anecdotes does not amount to data. There is zero data to show that the judgment of the United States will change one iota around the world if we close GTMO, particularly if we build a new GTMO in Illinois or Colorado or wherever it is. They will just transfer their complaints. And in terms of a moral issue, yeah, there's a moral issue, and it has to do with the people you've been talking to in these overseas locations. Because if they are morally valid people, then they would look at the conditions today at Guantanamo, and particularly, I would suggest they ought to compare it to some British prisons, if you've ever been to a British prison. And I would suggest that, morally speaking, we are doing more than the right thing in the way that we're detaining people in Guantanamo. And if you look at these statements from General Petraeus and so forth, you're talking 2008, 2009, 2008, 2009, and the world has changed a lot. I don't think it's going to make one iota difference. And we're just going to have a new place right here in the United States that will be the focus of all the program that's already.
We should move on, but let me just say I'm in violent agreement with Charlie to add my personal experience. I'm probably BBC's favorite ugly American. I've probably done more BBC interviews on this issue. The lamentations are not about Guantanamo. Lamentations primarily are about indefinite detention, military detention, the fact they're not treated as criminal suspects. What is at stake here, let's be honest, is the future of military detention. I'm not challenging anybody's, integrity here, and when people say in this panel, I believe in military detention, I take it on board, but the critics don't feel this way. So we're going to get nothing if we create Guantanamo somewhere else.
I respectfully disagree. I mean, I can fill the gap from 2008. I've traveled around the world, I've met with heads of state, I've met with foreign ministers. GTMO comes up every time. It is still a hot button issue, and it's a hot button issue in the intel community. Raha's group published a document that had 31 instances of which GTMO has been used as a propaganda tool and has caused diplomatic issues. I think it's still an issue. GTMO North would be less of an issue than GTMO now, because we could say to the world, we've addressed your issues, there's no allegation of torture, we're starting from scratch, the media can get there, they don't have to take a plane and a boat and a train for 3 days, they can get there. It's not going to take every issue off the table, but as my grandmother said, it's going to make it more better.
But Paul,
Well, I would agree with your
I
intention.
don't understand the argument that if, assuming that torture occurred, which I disagree with. Torture, are you saying, for example, in a federal penitentiary, or state penitentiary, if somebody said that 3 years ago, untoward conduct by warden occurred, we should shut it down and build it somewhere else,
No, but
versus cleaning it up? With respect, that's absurd.
No,
Why
that
doesn't make sense?
What you just said is naive. I'm sorry. I mean, I live in the Socialist Republic of Los Angeles, and my friends are, you know, not my West Point classmates, but my current friends are all very liberal, and Guantanamo, the word has taken on a meaning which is totally removed from any understanding of what the current conditions are.
Wrongfully so.
Yes, no, look, I get that, they don't know what the current conditions are. The word has taken on a meaning which has to do with waterboarding and CIA renditions. And while it might be, it's
There's
window
nothing to do-
dressing,
well,
it's
there's
window
nothing to do.
dressing,
We
window
have to
dressing
respect.
is not insignificant.
We should respect that the majority of Americans do not want Guantanamo closed. And the majority of Americans do not want the detainees transferred to the United States.
I can assure
We
you,
should
my
be
friends who
respectful
want
of that.
Guantanamo closed
And
would not be
I
willing to
think
have them
in
moved to
LA
Los Angeles.
No, but I think,
But-
Do they want the detention facility built in Silicon Valley?
No, I know they don't. I recognize the limits of their.
so
let's-
just
let's
a
move.
couple of points. I think what you raise is important, is that Guantanamo is always going to be associated with that.
Yeah.
And even if it's not true today, and it's not true today.
It's never
The
been true.
conditions are good, but
Nobody was waterboarding Guantanamo.
people don't understand that.
Right.
The general public doesn't understand that. And I think with respect to data out there, I don't know what the data is. We don't know what the data is about how countries are going to feel in the future. But I think a more important data point would be, how is Guantanamo being used in propaganda? And my information is not current right now, but to the extent Guantanamo is being used as a recruiting tool, it is in our national security interest to find a way to get around that, to close it down.
Well,
And I can tell you, in propaganda in Southern California, it's still being used.
Well, if people in LA are going to join ISIS, then that's a
No,
different issue.
that's
But
not-
here's the point. There was a study that was done on its own lawfare, where they found that it wasn't being used as a recruiting tool, and to the extent that it was, it's never going to disappear. That's the point. And I think,
Well,
in
that's just
terms
not
of,
true.
well,
When was the study done?
2015.
Yeah, 2015.
There are examples since then.
Well, and there's always going to be examples, but I would like to see the example where there was a single individual who, but for the existence of Guantanamo,
Wouldn't have been right.
became a terrorist. And I don't think there is such an example. And the reason people are joining terrorist organizations don't have anything to do with Guantanamo.
Well, so can we get granular about this too? Because it's the proposition, we can't have the proposition be, we're going to close Guantanamo and then the whole world's going to say kumbaya and everyone's going to love America, right? I think we all on this panel agree that is not going to happen, right? The question is closure of Guantanamo going to make an appreciable difference in terms of improving our counterterrorism cooperation with allies, reducing the propaganda value to terrorist organizations, or otherwise having incidental benefits to the national security? And if you take a different model, which is the federal government's efforts to counter violent extremism through social media and whatnot, they put in an incredible amount of value on the social media propaganda efforts of terrorist recruits. They can't draw a specific causal line between the propaganda that terrorist groups use to recruit people or inspire attacks and a specific attack, but it's still an incredibly powerful tool that the enemy has, and we need to take efforts to deprive the enemy of that. So I think we can debate about the value of the propaganda there,
We
But
need to move on with respect. Let me just say one thing, and I'll ask just one thing. Look, perhaps ironically, let me be a little Trumpian and say this. I would be prepared to discuss with our allies closing Guantanamo, provided they're willing to put something on the table. What they should put on the table is, first of all, fulsome apologies about terrorist thought criticism, which is not true, and renewed commitment to some aspects of the laws of war paradigm, which they've been unwilling to give. For example, if we move Guantanamo, would you be willing to transfer enemy combatants whom we captured to us without insisting that they be treated and processed for civilian justice system, without seeking assurances about death penalty? Put something on the table, so it would be like a fair trade deal. Let's not address closure of Guantanamo on its own, because the existence of Guantanamo is not something you can look at seriously without looking at the broader issues. And I would bet you anything, we're going to get nothing from allies. We're not going to get one concession.
We haven't tried though, but I agree with
Okay,
you.
but let's try. That's not the way it's been tried.
It's closing Gitmo, and what are we going to do with future captures?
But also I would say, stop stating stupid stuff about rules of engagement and criticizing drones. I mean, show us that you're willing to be a responsible democracy when it comes to
We
use
have
of
many
force.
countries that work with us on counterterrorism, we know that.
Yes,
And
but not publicly.
I think Paul is making a point here, and it actually sort of supports what I was trying to say. The Pew Research Center did a in their global view in 2014. They found that nations, with rare exceptions, were violently opposed, not violently, but very much opposed to our surveillance system and to our drone operations. But, notwithstanding grim figures on those two topics, overall, 65% had a favorable view of the United States. So I think that this idea that we're not getting cooperation from allies because of Guantanamo, even though they know people are being treated well there. I don't think that that's an argument that's gets us anywhere. I don't think there's any moral case for closing Guantanamo if you're treating people the way they should be treated, and I think that is the case. Because I think you'd just be establishing a new Guantanamo, and that place wouldn't even be open before there were lawsuits by.
Hey, we don't take positions on particular cases.
Yeah, that's true. No, in fairness, that is really true. There would be lawsuits that would be alleging, it would just become the new Guantanamo.
It's a good point. From a practical point of view, it's hard to see a Guantanamo North ever opening.
All right, well, that's spirited discussion. Let's move on to other issues. What do you all think about the question of, all right, so we're going to operate some Guantanamo somewhere else. We have a population of captured enemy combatants. There are 41 today. There may be more tomorrow. What kind of process is appropriate as a legal matter and a public diplomacy matter for weeding out people who can be released? Are you all okay with the notion that the traditional principle you detain captured enemy combatants, including POWs, lawful enemy combatants, for the duration of hostilities, and if it's another 30-year war, tough. There's nothing wrong about it as a matter of law. Or do you think we should release people after a few years, no matter what's happening in the war front?
Yeah, I mean, so I think there was a lot of comments. I'm probably uniquely in a different position than I think probably most of the panel on this is. There was a lot of comments made presuming the law of war paradigm and the establishment of enemy combatant status for everyone at Guantanamo and all ISIS members and all Al-Qaeda members and this kind of thing too. I think that's an assumption that's worth questioning, right? So most of the people at Guantanamo were in fact not picked up by our military. They were not picked up on the battlefield. They were picked up by foreign security services, foreign law enforcement, in fact, primarily. These are individuals who historically we would have treated as criminal suspects in any other scenario. But because we had a particular armed conflict in Afghanistan, all of a sudden now there's this effort to sort of rebrand terrorism suspects as enemy combatants and rebrand these crimes as law of war crimes that are put in military commissions. But let's assume for a moment that the premise that's being advanced here, that all these individuals are enemy combatants.
Can you just explain, if I may, forgive me,
Sure.
Is it an evidentiary issue or is it a conceptual issue? You think there's not enough evidence to enemy combatants, or you think that if we captured Osama bin Laden in Pakistan because he was captured in Pakistan and not on a battlefield in Afghanistan, he would not be in a lawful enemy combatant?
Well, so I just raised the geographic issue, but I'd say it's a conceptual issue and it's an evidentiary issue. So I already presented some evidence for why we should doubt that these are in fact enemy combatants picked up on the battlefield. But I think conceptually, to go back to some of the points that Charlie made, these are not individuals who wear uniforms, who look anything like the past armies that we fought and the troops that we've detained in past conflicts. I'm willing to sort of concede that there's also a room for security detention of civilians in armed conflict, but if you actually look at Common Article 3 of the Geneva Conventions, there's not a whole lot of content in there that articulates a detention regime. To the extent that you want to analogize or use other aspects of the Geneva Conventions, You're talking about a security detention regime of civilians, which only allows detention so long as they pose a security threat, right? So if you now want to talk about a standard there, this idea that you hold someone for 15 years, you know, in an armed conflict scenario, that is literally unprecedented in the history of modern warfare. So it's sort of surprising for me to hear folks say, you know, this is tried and true, you know, we always detain people in armed conflict. We don't actually have a concrete example of ever detaining individuals for upwards of 10, 15, 20 years in any armed conflict. In fact, if you compare what's happened at Guantanamo to the military detention operations that happened in Iraq and Afghanistan, it is night and day. What we did is we picked up individuals, we detained them oftentimes for days or weeks. Occasionally they'd be transferred to a regional detention facility and held for upwards of 6 months, and a very, very small portion of them would be held for longer periods than that. But that is not how the military had trained to do detention operations. The kind of detention that's happening in Guantanamo is actually quite sui generis and alien compared to other forms of military.
Before we go to Paul, I apologize. This just underscores that I'm right when I'm talking about follow fundamental principles of stake. And by the way, the category of lawful enemy combatants is not captured by Geneva. Geneva Convention is an important part of a totalitarian laws of war. They're not a complete codification. Unlawful enemy combatants have been with us as a category for centuries.
What's your source
and
of
the
law
reason,
on that?
read the writings, read the practice, and the reason why we've not detained unlawful enemy combatants for years is because prior to a more civilized time, they were executed either summarily or after a very short battlefield trial. And the notion for it, ladies and gentlemen, was actually the one designed to buttress humanitarian aspects of the laws of war. War is horrible enough with properly uniformed, properly led, properly trained troops. The last thing you want is to have individuals who use force and not comply with those criteria. So the reason you don't have an experience of multi-year detention is because they just did not survive. But you know as well as I do, that what you call them privateers, enemy combatants, unlawful enemy combatants, this category has been with us since the Middle Ages, and under different names before. And not enforcing it is the gravest of all sins against the integrity of the laws of war and humanitarian aspects thereof, because you are giving incentives to people not to comply with the four requirements.
So let me agree with you.
Let
me agree with you on just one point, and I think this is an area where we can all agree, surprisingly, it might be one of the few areas, but I am not disputing the right and in fact even obligation of our military in theater to engage in internment operations and detention operations as an incident of military necessity, right? And I certainly would not want to incentivize uses of force when there's an option to capture or detain. What I am trying to articulate here, based on facts and evidence, is that what we have seen at Guantanamo bears very little resemblance to the kinds of in-theater military detention operations that we've seen post 9/11 in Iraq and Afghanistan.
There's nothing in the laws of war that suggests that unlawful enemy combatants have to be detained in theater. And it's not a matter of military necessity, so maybe Charlie and I disagree. It's not security detention. You need, word discriminate is fraught with all sorts of baggage these days, but you need to discriminate against unlawful enemy combatants, not just for the sake of the security imperatives in the theater of combat, but for the sake of upholding the integrity of the laws of war, who are under serious attack in the 21st century.
I will disagree with you a little bit, David. It is security distinction because we're in an Article 3 non-international armed conflict. And so, and I do agree with you, we are in an unprecedented period. And I think it is a fair argument to say, is an Article 5 tribunal, is that enough to keep somebody until we decide they're not dangerous, or should there be a more robust process? And I think that, in the Nuremberg trials, they said the law of war evolves to meet the needs of, current circumstances, which is what they use to get to suddenly criminalize individuals, which had never been done before in the law of war. So I think there's a legitimate argument there that says, look, if you're doing law of war detention, we need a more robust process when you're talking about keeping people for 15 or 20 years. And now that's to be distinguished from saying that everybody you get has to have a criminal trial or a military commission criminal trial. It may be something other than that, but I think that is a norm that we need to think about, because we are now in in a situation that's going to go on for certainly longer than my life, but probably even longer than your life. We're entering the age of the super empowered individuals, Thomas Friedman says. We got to deal with it.
Am I wrong that there's not even decades, but centuries old historical practice of dealing rather harshly with unlawful enemy combatants? And all we've done is brought additional levels of due process and protection, frankly treating them at the level that is comparable to POWs. And I understand the case as well as you do, but I absolutely don't believe the Geneva Conventions banned this category. Okay, but they dealt with it. I understand the case that talked about why Geneva Convention applied, at least as far as the basic protections are concerned. I mean, let's not be lawyers for a second.
But, well, okay, if we want to talk history, there's history on both sides of that issue. I mean, there is history, as you say, where the defeated were executed or sold into slavery or whatever it is, but I happen to be reading the history of Hannibal right now, and Hannibal actually took a lot of Rome's allies and sent them back to Celtic regions where they had been dragged. So there have been different ways of handling this.
Has never been, that's not fair.
And I am sympathetic to your point of view, where we cannot get to the point where we start privileging
unlawful enemy combatants.
Unlawful enemy combatants by giving them a criminal law structure simply because they have not complied with the law of war, so that we could...
By definition, not on an individual basis.
But we are in a new era. New era, we need to start thinking new, and part of that would be, I think, looking at, okay, what do we do? Is our present procedures enough, or should we have, you know, even a judicial process? I hate to say that, for this particular situation. If we get in a war with North Korea and we have 400,000 POWs, we'll treat them as POWs. We don't have to fix that. We got that. But now that we're in this forever war, and I think it is a forever war, and you know, the enemy always gets a vote, and they're not voting to end it anytime soon. So we probably need a more robust process.
Always.
We all agree this is an evolving process, and it's a complicated process. I think the president, whoever the president is, needs everything available. The toolbox should be as broad as possible. So Article 3, military commissions, in-theater detention, out-of-theater detention. Let the president do what he or she thinks is possible. Article 3 courts are fine. We've tried to GTMO detainee who's got a life sentence. But Article 3 courts can't handle 400,000 detainees. They can't. So you have to have an alternative in warfare. So give the president all the tools possible and let the administration decide. I do think we're in a new world, though. I think it's not sustainable to detain people indefinitely without some sort of review process. So,
More than what we
yeah, the process we have is a good start. It's pursuant to an executive order by the Obama administration, but every 3 years, the detainees at GTMO have their file reviewed by career professionals, and they make an assessment as to whether they're a continuing significant threat. Transfer them if their home country wants them or another country wants them. We don't have to detain everybody. They do have they have a right to counsel. Every 6 months, their file is reviewed. I would encourage the administration to keep that process going and to consider building on it. I would actually encourage the administration. There are 5 detainees that are eligible for transfer from GTMO. The same body made the determination that they don't have to be detained at GTMO. So while it's not, you know, what the policy of this administration is, if you have a country that wants to take one of these 5 detainees back and do it in a way that they're watched, that they can't travel, that they are reintegrated, at least consider it. I'm not saying they have to be transferred, but keep that option open.
Paul, can I ask you a question? Sure. And let's not debate how many individuals who have been transferred, returned back to the battlefield. It's not important. Let me ask you this. So your sole emphasis would be, do we still pose a security threat? Let me ask you this. Would you prepare to accept a bargain where there would be greater evidentiary burdens in proving that somebody's an enemy combatant? But if you prove that somebody's an enemy combatant, and let me dramatize it as a hypothetical, most pathetic, weak, enemy, unlawful enemy combatant. Never done anything, just enrolled in an enemy combatant organization.
A cook.
A cook, all right, a lorry driver, but it's not been that. A soldier, but he could not shoot straight.
Low level.
But below level.
Low level.
Okay, but would you be prepared to accept the proposition that it's proven beyond a shadow of a doubt, because of a danger posed to the world, not just to his country, by unlawful enemy combatants, which always been the case, but particularly pernicious now, with weapons of mass destruction, et cetera, that person would be subject to the death penalty, because it's a status offense. Because in the past, historical practice has been to capture them in the battlefield, out of uniform, you get a little due process, you get shot. Because the whole idea was, don't do it. You want to deter other people. So would you be prepared to trade off?
By the way, that's a war.
No, I don't accept your proposition.
No,
I don't think
it is a
there's
war
been.
crime.
I don't think there's been unilateral executions. There have been some, but there was not the policy of the
I said
country.
due process. I said due process. Like, I mean, indulge me for a second. Would you be prepared to trade off much greater evidentiary burden to prove that you're indeed an unlawful enemy combatant, a pitiful one, but an unlawful enemy combatant, and that membership, that status, is enough of a crime under customary international law of war to merit your execution?
No, I don't think we're in a position where, because you're an enemy, that you deserve to be executed.
Unlawful enemy combatant with respect, not a lawful.
Well, let me jump in and then Charlie. I'm prepared that we have detention of the enemy. We have a right to keep the enemy off the battlefield. If you want to prosecute somebody for being unlawful, that's a separate proposition. Charlie?
That's what
I
I
was suggesting.
We are in violent agreement. Yes, during World War II, Otto Skorzeny's, I forget the name of the operation, when he sent German troops behind U.S. lines in American uniforms, they became unlawful combatants. They were tried by field courts-martial and they were executed.
It was not a war crime.
And it wasn't a war crime. But this is not that. That was what we would call today an Article 2 state-on-state conflict. We are now in a situation where we are dealing with non-international armed conflict. We need to have security detention, but merely being a member, it's just not the same thing. The incentives aren't there to even make the law. And there is nothing in customary international law that I'm aware of that says in a non-international armed conflict, merely being a party to it, which is not a traditional government force, makes you subject to the death penalty, merely for that fact. If there are individuals within that group that have committed what we would consider war crimes in non-international armed conflicts, and some of those could carry the death penalty, I think that there should be, Jens Olin has written a law review article about death penalty for crimes in non-international armed conflicts, so you can have them, but it's not an across-the-board thing, and I don't think that that's...
2 points.
That's what I was trying to say.
It's a lonely place, but I would say the following. First of all, as a matter of history, I would argue with anybody, but if you look, for example, at the practice of condottieri companies, which occasionally fought for Italian city-states and occasionally fought on their own account, that unlawful enemy combatant category arose not because you had armed forces of a state fighting out of uniform, but because you had private bands of people waging war. And everybody believed, even at that time, that having private individuals wage war without any discipline, without any chain of command, is such a bad thing, long term, that they need to be suppressed. It's a fact.
Well, okay. In the Lieber Code, the Lieber talked about summarily dealing with brigands and so forth, but that's not where we are. And I think that we can spin our wheels and as an academic exercise, but there is I can't imagine any senior commander in the armed forces of the United States who would ever support a proposition where every person picked up in a non-international armed conflict who was a member of the organization should be summarily executed.
Well,
and the American people You don't even want to think about that.
I support detention, I support prosecution, but I think what you're saying, David, is not sustainable. We barely
Well, it's not even
execute
on the table.
anybody in the
You know,
country.
I mean, candidly, we've gotten far afield. This is not a policy proposal that's on the table today. And I would say if we really want to be informed, let's look at what's actually happening. You know, at Guantanamo, in the military commission.
Current state practice.
Current state practice. And I think that will inform us all. And to me, it's ironic, this conversation about, well, we need additional flexibility to deal with unlawful enemy combatants, because by designating these individuals unlawful enemy combatants, by putting them in Guantanamo, by subjecting them to military commissions, we have hamstrung the government's legal options. If you're looking right now at, let's just take the military commissions. I gotta be careful what I say. We have Harvey Riskoff in the back there, our new commuting authority. But you know, we take the Nashiri case. This is a case of the bombing of the USS Cole in 2000. The defense in that case is arguing that because we're treating these individuals as unlawful enemy combatants, they have a combatant's privilege to bomb our ship. They are privileged to do so, and it's lawful for them
an absurd
to do
argument
so.
because
But
lawful
they would
combatants
never.
have,
But
by
let me
definition,
finish my thought.
no right to be evil.
Let me finish my thought. That is an argument that would never fly in a murder prosecution in a federal court, an Article III federal court. You would have that charge, and you'd have dozens of others that would easily be able to move forward. So, you know, when you have these kinds of, and beyond that too, the nexus to armed conflict, you're talking about an attack that occurred in 2000, before we invaded Afghanistan, before the 9/11 attacks, and they're arguing in that case, again, it's the defense is arguing in that case, that this is not occurring in the context of an armed conflict, right? And they have a reasonable shot at winning that.
That's a fair argument.
But my point is that we have been insisting in this conversation on military detention, on application of the law of war framework, purportedly because we want to have additional flexibility for our government to deal with terrorism suspects. But if that's what we're really looking for, I would suggest that we look at the nearly 600 cases of international related terrorism suspects who have been convicted in federal courts in the United States, including many who have been apprehended abroad in very difficult circumstances, that have not been, you know, subjected to the kinds of legal challenges and legal scrutiny and diplomatic challenges and all kinds of policy issues that we're seeing that arise directly out of application of the law of war.
Well,
let's move on.
Before we start canonizing the federal court system, I think there's actually, if you look, I can't believe this is coming out of my mouth, but if you look at the report of Human Rights Watch about those, quote, terrorism prosecutions, what they will tell you is many hundreds of them are, quote, hapless teenagers who were subjected to an informant, and they weren't, it's very hard to prove entrapment in this country. But they would argue, Human Rights Watch would argue, that these were people who had never had the capability of ever doing anything. A bunch of teenagers doing stupid stuff, that's a shocker, and were led into these conversations.
I don't disagree with that point. My point was that, you know, and I'm not saying that every single individual who's been convicted in a federal court is worthy of conviction or should have been prosecuted in the first place. My point is that if the goal is to maximize the flexibility of the federal government to incapacitate terrorism suspects, I don't think you can look at a record of 8 convictions in the military commissions, 4 of which have been overturned on appeal, at least partially, and 600 convictions in federal courts, and argue with a straight face that somehow we have added flexibility there.
Well, I think we should have all the
We
options.
should have all
All the options.
Nobody is.
Let's hear that from the other Paul.
Yeah, I apologize for being so silent.
My fault.
I have to caveat that I can't comment on anything, that I need to avoid commenting on anything I may have dealt with, and nothing I say is representative of what the government, the current or the former administration may believe. But, I mean, I think I actually agree a little bit with everybody. There are recent practice, and even practice going into this administration, has been to treat these individuals who are captured on the battlefield not as enemy combatants, and to bring them often to New York and sometimes other places to stand trial. And I think that has been very successful. And there are individuals who have been captured abroad, and there are some significant terrorists who have been convicted in that process. Although, as Charlie points out, there's a lot of really young kids who have been charged based on something that smells of entrapment. And, you know, but even excluding those, the prosecutions have been successful. That said, the prosecutions that are going on down in Guantanamo before military commissions are of a wholly different character than the ones that have occurred in the United States. These cases are very complicated cases. They involve individuals who were captured a long time ago. And of course, they're brought against individuals pursuant to the laws of war. I think going to David's point about trying to ensure that we do have a robust framework and we stand behind what the law firm complex says and the authority it gives us with respect to detention, just as we stand behind the authority it gives us with respect to targeting and conduct on the battlefield and other things. The administration needs to make a decision. How are they going to treat these individuals going forward? And when we take possession of an individual who's originally captured by security forces or law enforcement forces in another country, and if it's our military taking possession of that individual, is there any limitation on our treating them as a enemy combatant under the laws of war? Because they were originally captured not on the battlefield, not by the military, but by law enforcement. And I think we just don't have a whole lot of recent practice that would inform this discussion. Everything that occurred during the Bush administration. But these are really important questions that we should be asking.
Agree. I'm going to switch to AUMF, but let me just, I cannot help myself but say one thing. It's not just a matter of a result in an individual trial. The way a democracy, particularly a democracy like ours, handles particular problems is of enormous symbolic value. The reason we treat Social Security benefit denial one way, civil forfeiture case a different way, a criminal prosecution a third way, courts martial the fifth way, is of enormous symbolic importance. So I'm not that excited about how many people can be successfully prosecuted in Article III courts. We need to have a goodly number of people being prosecuted by military commissions, and we have not. Anyway, we can talk about it for a long time. Let me ask you all, look, we're operating essentially, the courts have said that the reason we can keep people in military detention, other issues aside, is not only because of the President's inherent powers Commander-in-Chief, because both political branches spoke in unison, putting us in the highest quadrant of Youngstown. That, of course, is based upon authorization to use military force that dates back to the early post-9/11 days. Now, we're not fighting against Al-Qaeda only, we're fighting against our organizations. There have been unsuccessful efforts in the previous administration to get another AUMF. I don't know how hard the administration pushed for it. I want to be fair. I'll be fair and say that both parties have not been very good on this issue, wanting to, as a price of that, having very crabbed parameters of President's authority to wage war, including such stupid stuff as saying, well, you cannot send ground troops, which is not what Articles 1's prerogative. I don't know many constitutional lawyers who would disagree with it. Anyway, do we need a new authorization? Do we need it badly enough to bargain hard for it and sacrifice something, or we can live with AUMF indefinitely?
So, just if I may, just clarify something and maybe just explain to the audience, if people aren't as well versed in some of this, that the Obama administration and the Trump administration have both taken the position that the 2001 AUMF does cover some of these other organizations that we are battling abroad, including ISIS.
Right.
And ISIS was part of Al-Qaeda, it was Al-Qaeda in Iraq until it broke off in 2004, and the position is that the 2001 AUMF continues to apply to ISIS as it would have if they had never done that. And there's a number of reasons behind that. There's legal reasons, there's policy reasons, there's also the common sense point of view that you can't allow somebody to simply rebrand themselves in order to get out from under the legal restrictions. So you can't pretend to file for bankruptcy and come out as a new entity if you haven't actually gone through Chapter 11, that kind of thing. So, you know, that said, I think that Congress has really fallen down on this. Even if you take that the 2001 AUMF applies with equal force to ISIS and some other organizations that have join the battle alongside Al-Qaeda or the Taliban. We're a long way from 2001, and the American people deserve some clarity. They deserve their leaders stepping up and making clear what the president's authority should be here, notwithstanding any additional Article 2 powers, and what it is, who our enemy is specifically, and what the terms of that engagement should be at a very high level.
I would agree with that.
Yeah, would it be worthwhile? But I mean, the real issue, of course, it would be nice to get new clean AUMF, but I don't think you would disagree if I would have posited in the current atmosphere, you're not going to get clean AUMF. You're going to get an AUMF that's encumbered with all sorts of restrictions, even certainly this administration, the same way it was with previous administration. Is it worth doing that? Is it worth, for example, accepting a constitutional AUMF and then having a signing statement which says I'm not going to comply with all foolishness about what forces I can use where, but I at least get your general blessing to wage war against ISIS and various other organizations, or not?
I think what a signing statement would say is that President would say that the President had authority already to go after these enemies, and appreciates Congress stepping up on this. And then beyond that, it would, but it doesn't curtail the President's authority in any way. Beyond that would depend on what other caveats are included in the AUMF that we see.
Well, I mean, I would say, and I don't profess to be a constitutional scholar, but I pal around with them from time to time, and I would disagree with your assessment. I mean, what Congress gives, it can take away, right? And so the President's Article 2 authorities, when it comes to using force, are limited to essentially repelling attacks and imminent threats and short-term uses of force, right? When the Congress conveys an authorization to use military force, especially when it also has the incidental authority through the appropriations function to restrict the use of money for particular activities, it can in fact put restrictions on there, and that's not a violation of the constitutional separation of powers. Whether as a matter of policy it's wise or not, I think is a different question. But I think that I think Congress has accepted, and I think both sides of the aisle in many ways have accepted that there is some ability of Congress to regulate how force is authorized, and including meaningful restrictions in that authorization.
I'll resist.
I'm
take a separate panel.
I'm with Paul on what I totally agree with him. So, and I do think he gave a correct rendition of what Raha gave the correct rendition of the law. But the problem is we now have, quote, the gloss of history, where there has been a number of pretty unilateral Article 2 actions where Congress has not interposed themselves, has not done anything about appropriations, and certainly had the opportunity to do it. So now we are building in a constitutional law sense some precedents for an expansion of Article 2. That's why I think what Paul's proposing is, and I think the signing statement would look exactly as you described, but I do think that we owe the troops in the field and the American people a full-throated discussion of this, because many of the detention issues that we're talking about are related to that.
Right.
And so step one in getting to where we need to be, and we can all agree, hey, law of war evolves, we're in a new era, or blah, 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 but all that requires action. And I think you'll find people, thoughtful people on both sides of the aisle, who will say Congress is falling down on its responsibilities. And what the scope of that is, and whether it infringes on Article 2, we can argue about.
Always.
Yeah, I'll put my hat on as former general counsel of the Armed Services Committee. The problem is, everybody agrees, in a perfect world, we'd have an updated AUMF. The AUMF is Al-Qaeda, Taliban, and those who perpetrated 9/11. So that is pretty outdated, even though now it's been amended to include associated forces. Problem on the Hill is...
It hasn't been amended.
I know.
To be interpreted.
That's how it's been
the
extended.
Congress amended the AUMF in 2011 to say associated
For
forces.
purposes of detention.
Right, for purposes of detention. Right, yeah, not for,
Okay.
yeah, right. Thank you for that. On the Hill, the The dialogue is the Republicans want to amend the AUMF and make it as broad as possible at the discretion of the president. If the president feels he or she can use force, fine. The Democrats want it scoped. They either want an AUMF for Indonesia, an AUMF for ISIS, or they want an AUMF for 1 year. And they just can't come to terms. It's a political problem. I don't see them overcoming it.
Yeah, well,
One point I want to add is that I think as we're talking about the AUMF, I think a clear statement from Congress about the scope of our current engagement would do more, and Charlie, I don't have the data, but would do more to help our relations with our allies than closing down Guantanamo Bay.
Just to show you how flexible my mind is, you don't need data for that proposition.
Well,
Self-proven.
we're running close to the end. Let me just say this again, another panel, but I would say the notion that leaving aside the use of appropriations, for which there is, of course, historical practice following the end of the Vietnam War, specifically post-Paris Accord, the notion that Congress can, for authorizing language, cabin what is one of the core powers of Article 2, Commander-in-Chief, by saying you can attack the left flank, but not the right flank, you can use minesweepers, but not destroyers, maybe you shouldn't actually helicopters, is absurd. I don't know of any serious scholar who maintains that. A notion that the framers, after the experience of idiocy,
How long
revolutionary war,
Well, we're not talking about
Congress
tactical
mismanaged.
execution here. We're
No,
talking
you
about.
can do it. What you can do, you can deny the president the tools. If you want to zero out the money to maintain helicopters, go ahead and do that and bear accountability, which is overarching constitutional virtue. But that you can prescribe the president how to wage war is.
Are you saying that Congress can't say that you have to detain individuals humanely in war?
No, no,
This is
no.
how, this is the detention conditions,
There's
and what they should
of
look like?
course, there's UCMJ, there's military commissions.
Those are congressional acts.
Congress, there is a measured tool. If you look at the Zivotofsky case, for example, when you're dealing with instances where both branches are exercising, neither is exercising legitimate authority, but both exercising legitimate authority, but they come into conflict. To the extent that Article 1 is doing something that does not impair the president's core ability to wage war, that's okay. And prescribing conditions of detention does not go there. But saying you can use, for example, special forces but not ground forces goes too far, it impairs the president's ability.
That's very different than an authorization to use military force.
No, but my point was that the authorization to use military force last time around was cluttered, okay, like barnacles. We have conditions on how you can use force. Am I wrong?
I think you're referring to certain efforts to restrict the use of large amounts of ground troops, right?
Yes. Yes.
And so,
Totally legitimate Constitution. Totally legitimate. Now, you can ignore them, but the interesting question for Paul is if you care about, and Charlie, if you care about symbolism, I have no doubt you're going to sign a statement and say I'm going to ignore it. All C would agree with it. But is it good for the American people to hear that Article 1 is supporting the use of force, but in a very cabin fashion, in a way the president is not going to comply? Is that a good thing?
I don't know if the draft that was on the table was very cabinet. I mean, there was strong sentiment among American people. There was a lot of polling on this that they didn't want the United States sending any ground troops to Syria. And so I think it was politically calculated to try and gain support. I don't recall there being a lot of other restrictions apart from that and the sunset.
Or is a temporal restriction?
Which also makes sense because I think it says we're going to be responsible about this and we're going to revisit this decision in 3 years' time and make sure that we still think it's the right thing to do. And it puts some responsibility in the hands of Congress and the president. I think that makes a lot of sense. I don't think
Congressional
that's
Research
extraordinary.
Service, by the way, has shown that about a third of prior AUMFs have had a sunset provision in them. And it's also worth noting that a lot of our national security legislation, when it comes to surveillance, et cetera, include reevaluation periods and sunsets.
And we got to remember, there's Supreme Court cases from the very beginning of the Republic, which talks about how Congress can, was Bass v. Taney, is that what it is? Can define when you can capture shipment. Oh, no, if it's going to a port, coming from a port. So yeah, I mean, that's been So I agree with you, if it gets down to tactical execution of attack on the right versus the left, then you're into what is commander-in-chief mean. But in terms of the broad restrictions, I'm with Paul, that there's, yes, you can say, no, we're not going to go into Libya. I mean, there's a reason that a declaration of war clause is in the Constitution. There's a reason that Justice Marshall ruled as it did in Madison retaining. So, it's hard to sit in advance and say, and kind of war game every single permutation, and there is a line there, I agree with you, David, but it's not in anything that I've seen that's being contemplated by an AMF. And I personally think that the American people would be wildly supportive of Congress getting anything done along those lines. And so this is where we need a little bipartisanship, and both sides are going to have to give on it.
Well, we've got an interesting discussion on amongst each other. We have just a few minutes. Does anybody have opinion? No? I don't know how much. It was enlightening. I think we agreed to some degree, disagreed with numbers, but I definitely feel I am to the right flank of this panel, so not surprisingly. Harvey? Well, thank you very much, everybody.
Thank you.
Thank you.